A couple weeks ago, I received a text out of the blue from Todd Williams, the Buncombe County District Attorney. Without saying why, he asked if he could be a guest on The Overlook. Now, it's rare when an elected official, let alone someone in the position of county attorney, initiates an interview with a journalist. I'm Matt Peiken, and this is The Overlook, a daily podcast about the news, arts, issues, and trends of Asheville, North Carolina. In my brief interactions with Williams during my time with Blue Ridge Public Radio, it was clear he isn't the stereotypical prosecutor.
Throughout my professional adult life, I've been very interested in ensuring procedural justice and ensuring due process on the defense side. And then also, I prioritize that in my campaign, because my predecessor had some problems with guilt and innocence.
So we sat down for an hour-long conversation and then a shorter postscript. You'll hear my interview broken up into 2 episodes. Today, we focus on Williams' path from social justice attorney to prosecutor and dive deep into perhaps his most controversial case since winning office in 2015, the assault of Johnny Rush at the hands of Asheville Police officer Christopher Hickman and the eventual dismissal of charges against Hickman. Charles Payne has seen what's wrong with public education from 3 perspectives: as a student, as a teacher, and as a Black American. With the help of the Magnetic Theater's program to cultivate playwrights, Payne has written a new work of art called The Classroom Ain't Enough. It's storytelling, poetry, and original music woven into what the playwright calls a choreo poem. Payne says the overarching message in the narrative is that a child only educated in school is an uneducated child. The Classroom Ain't Enough premieres June 2nd and runs through June 17th at the Magnetic Theater. For tickets, go to themagnetictheater.org. Before Todd Williams sought to become Buncombe County's district attorney, he built a track record of working for immigrants and the homeless, among other people who often don't find the system works for them. I began my conversation with Williams by asking what inspired an attorney with his background to work as a prosecutor.
Yeah, it's interesting. There's been a big pivot nationally in our justice narrative. I mean, there has been numerous bipartisan reforms. It's not necessarily a progressive, conservative, liberal, authoritarian, whatever labels you want to put on the political discourse. However, since my election in 2014, I sincerely believe that the election here in Buncombe County was an early forecast of what was to later be a wave of, they're often termed reform or progressive prosecutors in many larger cities. And I ran against a 24-year incumbent with a public defense background. I was actually an assistant capital defender at the time of my run. It was my work with the homeless community in Alamance County that led me to be interested in going to law school. Throughout my professional adult life, I've been very interested in ensuring procedural justice and ensuring due process on the defense side. And then also, I prioritize that in my campaign because my predecessor had some problems with guilt and innocence. And 5 African-American men were convicted on evidence that, at least in some of the cases, wasn't completely disclosed. The district attorney had DNA tests and analysis that had shown that a different group of suspects were implicated, which is exculpatory material that ordinarily would be disclosed pre-trial. Now, the test came in after the defendants, they were charged with capital murder, they were looking at the death penalty, they were offered a plea to second degree, and they pled guilty. And I think they got 12 to 17 years, something in that ballpark. And they were in prison, and then the test results came back showing that they were potentially exonerated, or this is evidence that could be used at a prospective trial. So look at the cost. It cost the DA's office immense credibility and community trust, so that a candidate, a political unknown, had no prior political experience in 2014, no prosecution experience in 2014, was able to defeat a 24-year incumbent who was thought to be unbeatable.
It's still surprising to me that somebody coming from your vantage, usually they're working for an innocence project. They're working from a defense vantage point. Why did you want to bring your personal ethic around all this to the prosecutorial side? Now, I understand you would say, I want to bring integrity to that position. I want to bring clarity and transparency to that position. And yet, you still have a charge, an edict in a sense, to prosecute.
Yes.
So why did you feel you, as a justice-minded, as a transparency and fairness-minded lawyer, why did you want to work for the prosecution rather than the defense?
Because I felt that it was time for systemic change in the system. I had seen people go to prison for 14 years for a false pretense that involved returning a $13 pair of shoes so that folks could put gas in their car. I had folks charged with low-level drug possession, just almost a speck of crack cocaine, that were then charged with habitual felon, and they went off for 8 to 12, 13 years. Since then, the legislature has modified the habitual felon law. And again, I earlier referenced that there have been some bipartisan criminal justice reforms. It's been a Republican legislature since 2010 in North Carolina, and a lot of legislative changes have occurred under Republican watch. One of them was the modification of this habitual felon provision here in North Carolina. I saw the overuse of that, and people were charged with low-level stuff that were going to prison for decades, or a decade. And it was an immense cost to the community, immense cost to families. It wasn't leading necessarily any better outcomes.
So you saw that from this position in this office, you could offer more discretion as a prosecutor.
Yeah. A theme of not only was the wrongful convictions and the innocence commission's work here in Buncombe County a headliner, bullet point on my campaign, but also the broadening of prosecutorial discretion to ensure that we're putting people on the right path in life rather than just getting a conviction and then stonewalling folks who want procedural justice post-conviction, as my predecessor had argued was appropriate. So it was a very powerful message, and it was certainly endorsed by the voters here in Buncombe County in 2014. And subsequent to that, we've seen it carry the day in multiple elections nationwide.
Once you were in office, what did you learn on the job that created conflict within you? On one side, wanting to bring reform to the position, and yet also having to make choices that may cause families and other people who are associated with the accused into discomfort and years, if not decades, of stress and trauma to families. What did you learn on the job that helped you, or have you learned that on the job that helped you balance the needs of the victims and the accused and the community and justice?
I've been answering this question ever since 2014 I announced my candidacy. And I just want to push back that it's not like I switched from baseball to hockey. It is law, there is procedure, there are rules of evidence, there are statutes that guide the process. And yes, changing over to prosecutorial work does require you to have more broad community issues in mind, accountability. You have to set precedents, policies for your office to ensure procedural fairness as to how you're going to handle classes of crime and certain types of offenders. So it's less than, as a defense attorney, your obligation is to your client. Your client wants probation. Your client is not guilty. Your client wants a shorter prison sentence in achieving their aims through filing motions, through arguing to a jury, through convincing a judge that probation is appropriate, whatever. You're obligated to your client as a defense attorney, but as a prosecutor, your head needs to be on a 360-degree swivel, not just continually oriented towards one person, if that makes sense. So that's the big adjustment that I immediately had to go through. And frankly, running for office, talking with voters, hearing their feelings on justice, and again, having their endorsement going through it all, did give me a lot of confidence that I was the guy to do the job.
You're saying that while there's been a movement in justice reform and that more and more prosecutors are coming from this more, I'll use the word holistic perspective, we don't hear that very often. And it doesn't seem like prosecutors get elected often based on being sympathetic to the needs of defendants.
It depends upon what your community is. In Buncombe County, we're a very compassionate, sympathetic community. I do want to say, in terms of our priorities, in terms of who we're considering for good outcomes, for diversions, for probation, for drug treatment court, veterans treatment court, sobriety treatment court, we're not talking about rape, robbery, and murder, okay? I've never said that we were going to do anything but prioritize the prosecution in achieving accountability to the best of our aims within the frame of doing all of our ethical work, which is disclosing everything, including the DNA evidence that exculpates the defendant. Because we can't go down that path ever again. Because look what the cost is. Not only to the folks who are convicted and spend years and decades in prison, but also to community feelings about what the heck is happening in the courthouse.
But it's not operating from an adversarial perspective. And not that it should. I'm not saying that.
Yeah. Traditionally, DAs have always run on convictions, years in prison, okay? Increasingly, I think even in I can point to a certain number of jurisdictions where Republicans have been elected DA, and they have done virtually the same. They've expanded treatment courts, they've expanded diversion, they've done expungement clinics, and some of the things we've done. They've done that in Republican districts too, because voters are more inclined to, people want folks who've spilled blood and victimized children in prison, and that's universal. But I think increasingly, especially with the onset of the opioid and fentanyl crisis that we have in this country, people want rehabilitation, and prison's not the answer for folks who fell off a ladder or went to war in Iraq or wherever and have PTSD or back injury, and that led one thing to the next. Those folks need help, if they can be helped. And I think DAs are increasingly obligated, not because it's something that they just have come up with, but because the voters and the public really want that. And here's another thing. Here in North Carolina, in 2013, the Republican legislature recognized that there are too many people in prison here in the state of North Carolina and passed the Justice Reinvestment Act. And that prioritized the incarceration of folks who've committed violent crime. North Carolina, under Republican leadership, has been a leader in decarceration. And that's something you don't hear. We have multiple diversion programs. And another class 3 misdemeanor is possession of less than a half ounce of marijuana. There's scarcely more than a fine. You're not going to, obviously with an unhoused person, you're not going to fine them. You can't fine an unhoused person who's basically on Skid Row or destitute or whatever. You're not squeezing blood from a turnip, if you will. I hope I didn't commit multiple sins there in that last sentence, but it's just not going to work, and it serves no punitive purpose.
Plus, I would think that a lot of people might say, look, there are a lot of people with money who have means who have less than a half ounce.
And they're not getting charged and caught because they don't have to do anything publicly. So I created an unhoused diversion program. What I'm describing is applicable to someone who is having a disruption in the ordinary course of their life that's led to a criminal charge, right? An unhoused person who's sleeping on a park bench shouldn't have to go to substance abuse treatment and do community service and do those kinds of somewhat restorative, but also in terms of community service, punishment type community reparations, if you will, type service. So the unhoused diversion notion is that I think we've had a dozen or two folks take us up on this, charged with panhandling, sleeping on a park bench, all those type crimes. They go to the unhoused program on the 15th floor, and I will let the public know that you don't have to be charged to access this, but they go to the 15th floor in the courthouse, the Justice Resource Center, and they have access to vocational rehab services, a computer terminal to send email, to print out resumes. They get some bus tickets to get from one place to another to improve their situation so they can become housed, basically, is the unhoused diversion program. The notion there is if we're just going to do this absurd kabuki dance thing of call somebody in who's unhoused on a ticket and then try to find them, we're losing a real opportunity as the courthouse as a node to improve or modify human behavior. We're losing that opportunity entirely. So my thought is give them access to some services, because what are we going to get? Even if we lock them up for a day or two, they're going to be out in front of the same business peeing on the sidewalk again because they're still in the same place.
Step into the weird, fantastical wonderland of Alice and the White Rabbit through the lens of Asheville Contemporary Dance Theater. It's a family show with colorful sets and costumes in collaboration with the new Studio of Dance. Alice and the White Rabbit opens May 26th and runs 6 performances through June 4th at the Intimate BB Theater in downtown Asheville. For tickets and info, go to the company's website, acdt.org. I'd noticed that the Twitter account for the Buncombe County District Attorney's Office is littered with posts about convictions it has secured, many of them around drug charges. I asked Williams how this squares with his focus away from prosecuting lower-level drug offenses.
The drug offenses that generally get up there, those are trafficking convictions. Those aren't possession. Those aren't lower level. These are people who are convicted of holding a trafficking amount of drugs. And with fentanyl, I'm sure some of that has led to fatalities in our community.
Yeah, and these people just are doing some serious time for this. And I was curious about your Twitter feed. Or have you used this as a vehicle for informing the public about every conviction and every plea deal, or is there a selective nature to this?
No, I generally use it to inform the public on cases that are newsworthy, that have prior press coverage, or they're just significant convictions. I'm going to put, even if there has been no prior press coverage of a homicide other than the announcement of the charge, when we obtain that conviction, I'm going to put that up there, and generally WLOS or the Citizen Times or somebody will pick that up. If it's a more significant case, I do a longer form press release. If it's just a notification that somebody has pled guilty of a significant charge and received time, it's just, this is what's happening in the courthouse right now. Matt, if you don't mind, I'm sometimes surprised that people don't know and understand what the district attorney does.
That's why we're talking.
It is, but I just thought maybe if I could take a second.
Yeah.
The Buncombe County District Attorney is one of 43 DAs in the state of North Carolina. We're divided into districts. We represent the state of North Carolina in everything from misdemeanors to murder and also in juvenile court. And we handle speeding tickets as well. And so our goal is to present the state's case, and the burden of proof is on us. Our goal is to always do justice, okay? And so that comes full circle back to what your questions were about diversion, right, or treatment courts. We actually have a stages on life's way kind of thing where if someone is entering the court system for the first time, we have a program called adult misdemeanor diversion. So if, not to personalize it, Matt, but if Matt comes in and you have a misdemeanor larceny, if you voluntarily adopt it, you can go into a diversion program, do community service, that will do an assessment for you, determine, do you need substance abuse counseling? Do you need a GED? There are these other prongs that go along with it. And if you complete that in 6 months or so, you come back to court. If the word is good, we no longer need to call our witness to the stand to prove your guilt because you voluntarily you made steps. And so in the interest of justice, we take a dismissal. We have a felony drug diversion that's a little bit more comprehensive. And if that's successful again, or it's not successful, you come back to court. We might have to prove the case against you, go to trial, whatever, ask you to plead guilty. And then down the road, we have more comprehensive court-involved programs like drug treatment court, where you would plead in and be placed on probation with a conviction hanging over your head. And your probation officer would be supervising you intensively for 2 to 3 years. And on the back end, once you graduate, drug treatment court, veterans treatment court, sobriety treatment court, we undo the conviction so that you can be set on the right path. So all these things are divergent from what you said was the traditional message from prosecutors, is get the conviction, potentially send folks to prison. And those are the options that we offer. Prison, probation, not guilty.
And it seemed to be that those were the benchmarks of success, were convictions and time in prison. At least that's what prosecutors tend to tout at election time.
Yeah, absolutely. And I have a pet theory about that. It basically goes to, I think we're learning more and more about human behavior, about neuroscience, about addiction, about mental health, all these things. And law does, in the most serious crimes, does come down to what the defendant's mental state was. And so we're learning more about psychology And the law does require proof of mental states.
Something you brought up earlier about offering nonviolent offenders different options that might lead to records being cleared, but perhaps correct me if you don't believe this is, but the highest profile case that I can remember in your time is the Johnny Rush case, in which APD officer Chris Hickman eventually had charges dismissed and expunged from his record. Some might argue, A, that it was a violent case. It was with a police officer in the line of duty, certainly at a time when a spotlight was on police treatment of particularly black men, black citizens. Now, I know he went through a program, a restorative justice program. Maybe you can talk a little bit about that and why you felt that satisfied enough criteria to lead to dismissal and expungement of those charges.
Yeah, so thank you for that question. There are facts and circumstances surrounding that I've never publicly addressed, and it's been a while. It's a combination of a lot of work with the victim, Mr. Rush, fully informing him about both the strengths and the weaknesses, and talking at great length about the risks of failing to achieve the felony conviction and secure the felony conviction against Mr. Hickman. So there's a lot to unpack there. Procedurally, prosecutors in each and every case are only as good as the investigation that we receive. And it's frustrating to be in the role that I'm in, especially in regard to this case in 2018, and not be able to communicate with the public and inform the public as things unfold. I'm obligated to refrain from doing that because of due process. Prosecutors can't try their cases in public. Prosecutors have lost their law licenses. So what happened in 2018 was, in January, I requested the SBI to investigate this assault. And the SBI declined it because the SBI said that the APD didn't report the offense timely, in a timely fashion. They declined it, and APD then took the matter internal. And I inquired as to why it wasn't, okay, the SBI didn't take it, but still a neutral police agency probably should have because of conflicts of interest within that agency. I'm in the district attorney's office. I can't direct how they're a separate agency. I can't direct their administrative functions within their agency, if that makes sense.
You're talking the State Bureau of Investigation.
Yes, I can't direct them, and I can't direct APD either. APD basically investigated themselves. And I made inquiry as to why the matter wasn't charged. Now, straight out of the gate, as soon as the police chief had reviewed the body cam footage, which we do not have access to, I'm not sure everybody's clear on that. We have access to it after the case is charged and the police disclose body camera footage to us in the case file. But we don't have, there's no YouTube back channel between the police department and we don't have access to things as they happen. But as soon as the police department became aware of Mr. Hickman's misdeeds, this assault, and apparently they publicly said that this happened in August of 2017. They took his badge and gun the next day with no notification to us. So we had no way of knowing that this thing had occurred, but they took his badge and gun. They could have, the police chief then could have, walked him straight over to the magistrate's office and placed him under arrest. Okay? They could have done that. They could have also immediately called the SBI for assistance and informed me as to what had happened with Officer Hickman. None of those things have happened. The SBI declined investigation. APD then took it internal. I inquired as to why it was taking, this is mid-February. I inquired as to why it was taking so long to complete the investigation. The Buncombe County Democratic primary filing period was to begin at the end of February in 2018 and end February 28th or 7th or something like that. It closed 12 o'clock, whatever date that was, and another attorney filed that morning, the very last day of filing for the Democratic primary. And the body camera footage that was part of the investigation, and nothing had been charged, but I had requested twice that the matter be investigated, was released to the media. It was released to the media by we don't know whom.
It could have only come from one channel, right?
It had to have come from APD. And I will clear the air and say the district attorney's office did not have that footage, so we didn't release it. And just to put a fine point on it, not trying to be a conspiracy theorist, but my world at that time was a day before, no one had filed to run for district attorney, all right? The day that someone files for district attorney, this body camera footage is released. And I don't know if the release of the footage was made to retaliate against my request that the matter be investigated or not. Ultimate facts, I don't know. I don't know what the motivation was. But it certainly put the investigation and the procedural posture of the case in a very compromised place. For the next 10 weeks, my primary opponent used this to launch his campaign, and I was in a position where I couldn't comment about the case. The matter was under investigation. It was then charged in early March, and I can't comment on a pending prosecution. And it was a high wire act in order to get to the end of that primary, win that election, and talk about it to the extent that I could about where we were in the process.
Can you explain why that video compromised your position?
Because whenever a matter is under investigation, and if you were under investigation for something and the police leaked out matters pre-charge, you would declare that your attorney would say that's a potential libel, slander, whatever, a due process violation.
Grounds for a mistrial.
Grounds for, absolutely. So it raised just a number of procedural questions. And never mind the fact that I think that the evidence in this case, the body camera footage in this case, was pretty egregious. And I do think that all things being squared away and equal, I think that we would have, if we had to go to a jury trial, we probably would have obtained a guilty verdict based on the body camera footage alone. However, that being said, it's completely unpredictable as to what a jury will do in each and every case. So here's the thing. If we didn't get the felony conviction, if the jury were to compromise, and juries, there would have been a lot of testimony at a trial that law enforcement is trained that in any fight, you don't know what the defendant might have on them, but you know that there is one gun in the fight, the gun that the officer is carrying into the fight. And you've got to control. I'm not arguing that this is proper training, but this is the training. And this is what would have been part of the testimony. And I'm pretty confident that Mr. Hickman's lawyer would have argued at great length that there was no intent to assault. There was only intent to bring his hands under control and all the rest of it. Now, I don't know how a jury would come out on that. But we needed the felony conviction to come back full circle. We needed the felony conviction to ensure that this officer would never be a police officer again.
So was that part of the conditions?
Yes, he pled guilty to the felony.
Yes.
And he surrendered his certification to be a police officer.
Anywhere, that he couldn't go back and try to reapply?
In North Carolina. I think if he goes to another state, and this is just hypothetical, if he were to go to another state and be a police officer in another state, there would be a record of the conviction.
It wasn't expunged to that point?
Yes, I think the official record is expunged. However, there's plenty of record. There's plenty of record on the internet.
I guess I ask about this because my vantage point is, why doesn't a district attorney, now I'm talking about this case or in any similar cases, if you have evidence and you believe you can get a conviction, the reason to bring such a case to a jury is so the public can see and hear an airing of all this, and that there's a public accountability, a public reckoning. And then, yes, a jury might not convict, but yet all the evidence is presented, and the public can't say that the DA's office treated this with kid gloves, that they worked in concert with the APD, their cronies, that there's a relationship going on here that needs to be fostered between police and prosecutors. You need cooperation from police, and there needs to be trust on each side in an ongoing relationship. I understand that, but I think a public might look at something like that and say, this isn't just.
Yeah, there was definitely a lot of debate about it.
And you said you talked with Johnny Rush himself about
multiple times. And so that's the thing, is that Mr. Rush understood many of the nuances in this case. He also was thrust forward in the public light that I don't think
nobody would choose.
He did not appreciate that. Yeah. And so he wanted the case done. I'm not saying he was an uncooperative witness, but he was interested in achieving justice without additional issues for him.
Did any of this result of this, of part of the dismissal and expungement was any condition that Christopher Hickman apologized personally to Johnny Rush?
Yes. And we made plenty of that public. I think you can watch the video of the exchange between...
I'm just asking because there are a lot of people who may not know.
There has been, in terms of public accountability, we put out the transcript of the meeting. We put out the video of the meeting. There was an in-court process. He did plead guilty as charged. Another thing is Mr. Hickman had no prior record. He was a police officer. And the media would say that the maximum punishment he could face is, I forget, 4 or 5 years if all the matters were boxcarred and he were basically a career criminal. But with his record, he was very likely to get probation.
I understand that.
It wasn't like we were giving up a long prison sentence. And then he did do a lot of comprehensive work in the restorative process. He did a lot of labor, donated tools to a youth program, made donations to another thing. The restorative justice practitioner who led this, early on he made comments that he wasn't sure that Mr. Hickman was engaged, but at the end of it he said he really seemed to embrace this work. And again, going back to where we started this conversation, I was elected in 2014. In August of 2014, predicate to that, Trayvon Martin was, I forget if that was 2012 or 13, but Ferguson was 2014. And since 2014, things have carried this momentum forward that's really led to this national dialogue on criminal justice.
But again, getting back to the question of what message does this send to the public when these cases don't go to trial?
It sends this. It says, no matter what the obstacles are, we're going to get justice. And if you do this, you're not going to be a police officer. That's what it says. And he went down pleading guilty to a felony. And so that's what it says. Now, if you take the procedural problems that this one case gave us out, it would have been a jury trial. It would have been plead guilty as charged, or it would have been. The evidence was strong enough to warrant that. But these other intervening circumstances came into play. The police tried to undermine the prosecution by leaking the video in advance of charges. And I don't mean to minimize that I will confess that these are very fraught procedurally, ethically. Law enforcement officers have the right to use force statutorily. And when juries get into those issues about what the intent was, how much force was used, whether it was excessive or not, the gray area where to somebody who's sitting in front of their YouTube channel and they see this, oh, by God, I would convict him. And it's very different when you're on a jury and you're hearing from the defense counsel and all these nuances come out and the judge is instructing you on the law. It's much more nuanced than I think the average person realizes.
I understand that. And yet at the same time, it seems that
I get it.
That so few of these cases even go to trial, that so many instances of supposed or accused police brutality, whether they lead to assaults or death, so few of them seem to go to trial. They are somehow dealt with behind the scenes.
We have tried a number.
You're talking about your office particularly?
Oh, yes. Oh, yeah. We have tried a number. And it chafes me to go through the list. I don't want to do that. I don't want to
I don't think
names.
You have to.
I don't want to do that. I will say here in the next week or so, we do have another officer trial set. So just to push back on, we're not doing that. We're only as good as our evidence. In the Johnny Rush case, in the Christopher Hickman case, we had very good evidence, but we had procedural problems.
It takes up all my time.
This was just part one of my conversation with Todd Williams. Among other topics, our next episode touches on his office's prosecution of people cited for trespassing and littering in Aston Park, so make sure to check your podcasting feed for that. Also, we've expanded our newsletter into a quick daily digest of news from all over the local media landscape. We promise we'll never make advertising look like editorial content. Subscribe for free at podavl.com/newsletter. Today's conversation was recorded inside the BB Theater in downtown Asheville. Our theme music, Maker's Song, comes from the Asheville band The Resonant Rogues. The Overlook is a production of Podcast Asheville. Get new episodes wherever you get your podcasts. I'm Matt Peiken, and I'll see you on the next episode of The Overlook.